And I want to begin this section by giving you an interesting perspective. And this perspective comes from sometimes an overlooked party in the deposition, and that is the court reporter. And it may seem that the court reporter has very little function in the deposition except to record what's being said, but I disagree with that. In fact, the court reporter has a very important role in the deposition. And if you've had any number of depositions, you realize this, particularly when you read your deposition transcript some 2 to 3 to 4 weeks after the deposition. And it's amazing that sometimes when you read the deposition transcript, your testimony as it unfolds in a deposition transcript might look completely differently from how you intended your statements to say, how you intended them to sound, or what you intended to say may not come across in the translation between the oral form and the written form. And that's because your message has to be filtered and percolated through this inert person in the deposition room, and that is the court reporter. So it's a good idea to get to know your court reporter prior to commencing the deposition. One of the questions I like to ask the court reporter is, how do they handle punctuation? And if you've ever read deposition transcript, you'll notice that many times the court reporter simply takes down words as they come out of your mouth without concern for the punctuation. And when your words are transcribed into the written form, if the punctuation is not right, it can convey a completely different meaning than the same sentence with proper punctuation. And some of the court reporters, and there are rules that govern this, but some court reporters have a more liberal application of their role. Some court reporters take down what you say and what you do. For example, if you gesture, if you indicate, they will simply transcribe that into the deposition transcript by using words such as gesturing and indicating and pointing, etc. So one of the things that I like to clear up with the court reporter prior to beginning the deposition is, how do you handle punctuation? For example, if I'm responding to a question from either of the parties and I want to indicate that some words that I'm going to speak, I'm going to want them to be in quotes. Well, in normal conversation, you might reach both of your hands up in the air and simultaneously wiggle your index and middle fingers to indicate quote marks. And that may or may not be a gesture that your court reporter may transcribe onto the written word exactly as you intend it. And that's something that you can clear up with the court reporter in advance. You can tell them that when you gesture and do this gesture indicating, for example, quotes, they know that you're indicating that your words are to be in quotation marks. Certain court reporters might indicate that you're trying to demonstrate quotes simply by writing down in written word on the deposition transcript indicating quotes. And that is not nearly as powerful or as impactful as if she simply put the words in quotes. Similarly, if you want to have a comma or a period inserted in any of your sentences, you can simply tell the court reporter comma or period, but make sure that the court reporter is synchronized with you in advance to be able to understand those directions and instructions. And most court reporters are compliant and cooperative with this instruction. And so get to know your court reporter and find out how they do things in advance. And what I want to give you now are also some things I've learned from speaking with court reporters and interviewing court reporters. And basically what I'm about to share with you has a lot to do with your perceived credibility in the deposition, which is important. You want to be perceived by all parties as a credible witness, and here are some suggestions from the perspective of this inert sort of third party, or fourth party, I guess, in the deposition room. Okay, so the following is a quote that I took down word for word from a court reporter at a recent deposition. She said, quote, "I figure the goal of testimony is, first, conveying your message, and second, convincing others that your message is correct." And unquote. So many of the following tips that I'm going to share with you from the perspective of the court reporter are aimed simply at conveying your message. Simply conveying your message, and conveying your message accurately so that the court reporter can transcribe it exactly as you intended it to be delivered. Further, quoting from the court reporter, she states, "Court reporters are probably the ones listening hardest to the testimony. It's our job. So if we can't hear or understand, neither can anyone else. The message never gets conveyed at all, and the witness, which is you doctors, can't ever hope to win over the other side." So in the interest of powerfully and impactfully conveying your message, please observe the following rules. Number one, when you come to the deposition, have on hand an up-to-date curriculum vitae. The purpose of a curriculum vitae is to establish your qualifications and credentials to be able to, number one, perform the QME exam, and number two, to be able to comment credibly on the issues in question in this particular case. Now, having an up-to-date CV can sometimes obviate the need for the attorneys to go through this entire process during the deposition itself. For example, it may eliminate the need for them to establish your credentials on the record in advance by having the curriculum vitae already document your credentials. And really, the credentials that are most important in this venue are, number one, that you're a licensed provider, whether that be a licensed chiropractor, a licensed osteopath, a licensed medical doctor, a licensed psychologist, etc. In other words, that you be licensed with your own licensing board, and that your license is current and not under disciplinary action. And then number two, that you are a current QME with Division of Workers' Comp Medical Unit. Really, those are the important credentials. Other than that, anything else that you choose to put on your curriculum vitae may indicate that you have special training in certain areas applicable to the deposition here in question, or that you have particular experience in dealing with the injuries in question. And all of that is information that you should highlight on an up-to-date CV. And when you get to the deposition, right up front, make sure to hand a copy of your business card and your up-to-date CV to all parties present. Number two, be amiable and pleasant. be amiable and pleasant. And your attitude during the deposition in large part determines the attitude of other parties also at the deposition. So there's really no need to be anything but amiable and pleasant. There's no need to be offensive. There's no need to be defensive. You're simply there to support the opinions that you rendered in your reports. And it's particularly easy to be amiable and pleasant. And I found this out through the School of Hard Knocks myself. It's especially easy to be relaxed, to be comfortable, to be pleasant, to be cooperative, and to be helpful if you're not particularly attached to the outcome of the deposition. Now, if for some reason you took a particular stance or a particular orientation in your report, for example, if you were less than totally objective and perhaps wrote an imbalanced or overly applicant-oriented report, or vice versa, you wrote a particularly defense-oriented report, and if down in your heart you're really not convinced in the opinions that you rendered, or you're not comfortable supporting your opinions, then it's going to be difficult to be totally relaxed during the deposition. It's it's easiest to be most comfortable when you're not attached to the outcome. When the opinions that you render are totally objective, it's completely consistent with the way you feel and the way you found the examinee to be, and that you're not tied to the outcome. It's only when you're not tied to the outcome can you actually really relax. When you are tied to the outcome, that comes across to all parties because it changes your demeanor. It changes your attitude. So don't be tied to the outcome. Be amiable, be pleasant, be relaxed, and you will find that the parties respond to you in like kind. Number 3, make sure to speak clearly, and this is especially important if you know that you speak with an accent. It's important to speak clearly so that the court reporter can accurately take down what it is you're trying to convey. Number 2, don't speak too fast. I'm sorry, that's number 4. Number 5, don't mumble, because no one can understand what you're trying to say when you mumble. So speak up, speak clearly, but don't speak too fast. Speak in a loud enough voice so that all parties can hear you. And not only does this allow all parties to be able to hear you, but it also projects your confidence or your perceived confidence in yourself. So it's interesting. People that are confident speak up, and they speak in a loud enough voice so that everyone can hear what they're saying. They don't speak in undertones or mumbles or half-audible phrases. That projects the emotion of lack of confidence, and that lack of confidence is picked up. It's picked up verbally and non-verbally. So speak right up. Next, be able to explain technical and medical matters in a way that lay folks, such as attorneys, judges, claims administrators, etc., can understand. If you must use technical or medical terms, make sure to spell those out for the court reporter so that they're accurately captured on the deposition transcript. If a layperson explanation is required to explain technical terms that will help the parties in the case, such as the claims administrators who have no medical background, or judges or attorneys, make sure to make those explanations to clarify technical and medical terms. Next, make sure to answer the question as it's asked. If someone asks you, do the Red Sox play baseball, don't comment about the Lakers basketball team. Make sure that your response is answering the question as it's asked. As always during depositions, because written testimony must be transcribed into the written form, when one person is speaking, make sure to not interrupt. And if you've ever read a deposition transcript where multiple parties are trying to speak at the same time, it drives the court reporter crazy because it chops up their transcript, and it creates for a difficult flow of the written word in the transcript. So let the other party completely finish their question or their comment before you offer your answer or counter comment.